Welcome back to Human Resources for the People. It's a human capital revolution. Today we're going to ask if your non-compete's going to be worthless. This article comes from Greenbaum, Rowe, Smith, and Davis. It's a law firm. Uh, Go check out the link down below to read this article in full. They have a lot of great information there. The FTC, the Federal Trade Commission, is proposing a ban on non-compete agreements. Now, non-compete agreements are sort of what it sounds like. They are an agreement between the employee and the employer to not work for competing parties in the course of the business agreement. So after you leave, you can't work for someone that would directly compete with you. January 26th, or sorry, on January 5th of 2023, the Federal Trade Commission issued a notice of proposed rulemaking which prohibits non-competes. And all of the government agencies do this, and from a layman perspective, it's a little bit annoying. It's not just proposed, they're asking you to make comments on it, but they won't really, I don't know, as far as I understand, listen to those comments. They just want to know what you think. And then they'll put it into place, and then it will be sued and sued and sued. And who knows if this will actually go through. But this notice of proposed rulemaking that's going to be created prohibits the use of non-compete agreements in most cases. And this comes from a July 2021 executive order by President Biden, which wanted to curtail the use of non-competes, although this is a little bit more than they expected. So I'm somewhat familiar with these with respect to EEOC. It's a little bit frustrating that Congress repeatedly sends its ability to make laws to non-elected officials. Federal Trade Commission has no elected power, yet they're creating laws which prohibit the use of non-competes, for example. And that's really frustrating from a citizen who believes in democracy and who isn't quite getting it in this case. So there's, like I said before, a 120-day comment period, and then it'll be effective 60 days after. So we should see this, in 5 months. There will be a lot of challenges, as the article says, and it may be slightly different from what was proposed. Which again is frustrating. Why put it out there if it's not as is? The amended copy should be then released. And employees got to be thinking what this means for them. There is impacts, both negative and positive, for the employee, and we'll talk about it in a bit. So this will apply to all workers, even those are on 1099, and there are exceptions, which they're ones that aren't really for this audience. If you own 25% or more of an ownership interest, there's a non-compete there. If it's a non-for-profit, there could be, which is odd, I think. That doesn't make any sense. Nonprofits can also compete against each other, so it is odd. But this mentions that it may cause individuals who might otherwise work for a nonprofit hospital to go elsewhere. And that's a great point. I don't understand why this is a part of the legislation. Once it goes into effect, it would apply to agreements that are in effect at the time. So if you currently have a non-compete and this goes into effect, it will go away. Um, Employers would have to give a notice to let employees know that the non-compete is going away and that they would no longer be enforceable. Uh, it- it talks about how other provisions which were negotiated in exchange for non-compete, including uh, severance payments, would remain in effect. So I think a lot of the problems with this stem from it's a interference in the interaction between employer and employee. I'll have to remind you that minimum wage was unconstitutional for a great majority of America's life. And it was unconstitutional because it was an interference in the negotiation and fair dealings between an employee and an employer. Um, it was imposing a rule on the employer and prohibiting free association. This has that same impact and that same effect, in my opinion, in my completely non-legal layman opinion. On the plus side for the employee, it may make it more difficult to terminate an employee because you wouldn't really want to terminate them for them to go around and work for the competitor after a severance. You would want to do your best to keep employees, which could be a benefit for the employee. Uh, the employer would have to really be very plain. But on the flip side, one thing that this could cause that people aren't quite thinking about is the idea that employers might poison the waters, poison the well, so to speak, on employees that are leaving, right? So they might go and tell a competitor, hey, this employee burned me or did this and did that. And while you could certainly potentially sue for defamation if there was damages caused for that, I, I don't know that you would be particularly successful, nor would you actually be able to nail down that it happened. And I think that's the real problem. This presents a lot of opportunities for the employees and the employers, but it also could cause a lot of problems. That's it today for human resources for the people. If you liked what you saw today, comment down below. Let me know what you think about the new rule. Let me know how you perceive it, and like, share, and subscribe. And I'll see you on the next one. Bye, guys.